Welcome to this joint presentation of the Wisconsin Resource Center for Charter Schools and the Wisconsin Association of School Boards. I am Barry Forbes, WASB Associate Executive Director and Staff Counsel. This session is part 4 of a 9-part series of programs designed for school board charter school authorizers. Session number 4, the Charter School Contract. Charter schools are created through an agreement between the authorizing entity and the Charter School Governance Board. The Charter School Governance Board must be a legal entity capable of entering into a contract. It might take the form of a non-stock corporation, a for-profit corporation, an LLC, or a partnership organized under the laws of the state of Wisconsin. The charter school contract will specify the location of the charter school. Wisconsin law places limits on where charter schools might be located. Charter schools authorized by one school district must be located within the territory of that school district. If 2 or more school districts enter into an agreement to authorize a charter school, the school must be located within the boundaries of one of the schools participating in that agreement. If the charter school is established by 1 or more schools and a cooperative educational service agency, or CESA, the charter school must be located within the boundaries of the CESA. If a school district enters into an agreement with a federally recognized American Indian tribe or band in Wisconsin, the charter school must be located either within the territory of the school district or of the tribe or band's reservation. Note that the virtual charter schools are not subject to these location restrictions. Wisconsin law places a number of other restrictions on what might be agreed to in a charter school contract. A school board may not enter into a contract that would result in the conversion of a private sectarian school into a charter school. A school board may contract with the governance board for creation of 1 or more charter schools, and a charter school governance board may enter into more than one contract with a school board. A school board may agree to establish a charter school that enrolls students of only one sex. Such school boards shall make available to students of the opposite sex schools or courses that are comparable to the single-sex charter school and courses using the same policies and criteria for admission. Required contract terms. Charter school contracts are limited to terms of 5 years. Authorizer boards should time the start and end date of the contracts to allow for the normal start and end dates of the school year. For example, you would not want to start a 5-year charter school contract on May 1 because the contract could not extend past April 30 of the 5th year, which would be before the end of a school year. The contract will specify amounts to be paid to the charter school during each year of the contract. Charter school attendance must be voluntary, and the charter school contract should indicate how the program and attendance in the charter school is voluntary. Random selection process. Wisconsin law requires that the charter school contract provide for random selection of students if the number of applications exceeds the capacity of the charter school. There are several exceptions. A charter school shall give preference in enrollment to pupils who were enrolled in the previous school year, and a charter school shall give preference to the siblings of pupils who are enrolled in the charter school. And note the use of the term shall. You don't have a choice in terms of allowing those 2 preferences. A charter school may give preference in enrollment to the children of a charter school's founders, governing board members, and full-time employees. But the total number of such children given preference may constitute no more than 10% of the charter school's total enrollment. And there the statute uses the term may, which means that the parties have discretion as to whether they include that term in the contract or not. A charter school under contract with a union high school may give preference in enrollment to pupils enrolled in the previous school year in a charter school operating under a cooperative agreement with the charter school under a contract with the union high school. And I am guessing that this addresses a charter school authorized by a union high school giving preference to pupils that attended a different charter school authorized by a K-8 school district within the territory of the union high school district. The charter school contract must include all of the provisions required for an employee petition for a charter school under 11840(1)M. Wisconsin statute section 11840(1)M identifies 15 different components of the charter application that must be included in a charter school petition and as required by section 118.40(3)A must be included in the charter school contract. First, the name of the person seeking to establish charter school. This typically would be the name of the legal entity created to enter into the charter school contract, or it might be the name of the person seeking to lead the charter school. Second, the name of the person in charge of the charter school and a description of the way administrative services will be provided. And the administrative services you might address in the contract could include things like payroll, benefits administration, labor relations, staffing, enrollment, pupil services, record keeping, and pupil testing. The contract must describe the educational program of the charter school. This is a description of how the charter schools plan to educate its students and how the charter school is different from other schools of the district. Remember that these are legally enforceable contract provisions. If a charter school contract includes a description of how the charter school will educate children, the charter school's failure to actually do that would be a violation of the contract. Next, the contract should describe the methods used to enable pupils to attain educational goals described in section 118.01. 118.01 requires educational goals relating to academic skills and knowledge, vocational skills, citizenship, and personal development. The contract may address other educational goals beyond those required by section 118.01. The charter school's educational goals is a part of its educational plan. It has a contractual obligation to achieve those goals. A charter school's failure to meet the requirements of this part of the contract may be grounds for contract non-renewal or revocation. The contract should specify the methods by which pupil progress in attaining educational goals in the last slide will be measured. This is where the authorizer identifies the data points that it will use to judge charter school performance. Those data points will usually include state-mandated student assessments and other district-wide student assessments, and may include a variety of other measures of student performance and student and parent satisfaction. Other data points might include student attendance, discipline, promotion, and graduation rates. The contract should include terms describing how and when the charter school will share the data with the authorizer school board. The contract must describe the governance structure of the charter school. The charter school must be an independent legal entity capable of entering into a contract. That legal entity must have a governance board. The articles of incorporation and bylaws of the charter school might be attached to the contract as an exhibit. The contract must specify if the charter school is an instrumentality of the school district or not. Employees at instrumentality charter schools are employees of the school district. And as an example, if the district employees are covered by the Wisconsin retirement system, then employees of an instrumentality charter school would also be covered by the Wisconsin retirement system. Employees of non-instrumentality charter schools may not be employed by the district. Those are employed by the charter school. The structure of the governance board is described in the contract, which should address the following questions. How many persons will serve on the governance board? How are those persons appointed to the governance board? What are the qualifications of persons serving on the governance board? Will positions be reserved for employees of the charter school or employees or officers of the school district? In section 11840, paren 3 allows this as an option, but I have questions as to whether an employee of the charter school or certainly a member of the school board might have either a conflict of interest or an incompatibility of office or position problem if serving on the governance board. Other questions relating to the governance board: what is the term for persons appointed to the governance board? Will board positions be reserved for parents, district staff, or community members? Are there term limits? How are vacancies filled? And how often will the governance board meet? Parental involvement is required in charter schools, and the contract needs to describe how the charter school will ensure parental involvement. This might be through inclusion of parents on the governance board or creation of a parental advisory council. This part of the contract addresses governance the part of the contract that addresses governance structure must include several other provisions required by section 118.40. If the charter school replaces a public school in whole or in part, it should give preference to pupils who reside within the attendance area or former attendance area of the charter school. The charter school must be non-sectarian in its programs, admissions, policies, employment practices, and all other operations. The charter school may not charge tuition except as otherwise provided in section 12183, paren 4, and that statute requires a virtual charter school to charge tuition to pupils attending the school who are not residents of the state of Wisconsin. Except as provided in section 118.40, paren 3, paren H, discrimination in admission or denying participation in any program or activity on the basis of a person's sex, race, religion, national origin, ancestry, pregnancy, marital or parental status, sexual orientation, or physical, mental, emotional, or learning disability is prohibited. Section 118.40, paren 3, paren H references the exception that allows for single gender classes under certain conditions that I talked about earlier in this presentation. This part of the contract on governance structure should also describe the autonomy of the school board, the autonomy of the governance board by identifying the scope of its decision-making authority. This might include any of the following: the authority to receive or disperse funds for school purposes, to secure appropriate insurance, enter into contracts, incur debt in reasonable anticipation of the receipt of funds, pledge, assign, or encumber its assets to be used as collateral for loans or credits, solicit and accept gifts and grants for school purposes, acquire real property, and sue or be sued in its own name. The contract must next describe the qualifications that must be met by individuals employed by the charter school. At a minimum, teachers and administrators must hold the appropriate license or permit required by the Department of Public Instruction. Note that there are special rules for virtual charter school teachers that will be addressed in Section 5 of this training module. The contract may specify additional qualifications for charter school employees. The contract must identify procedures that will be used to ensure the health and safety of pupils. At a minimum, this requires compliance with all applicable laws concerning health and safety. It may also require the charter school to follow school board policies, or for the charter school governance board to create its own policies relating to health and safety. The contract might also require employment of staff or services by the charter school related to the health and safety of pupils, such as social workers, police liaisons, or school nurses. The contract should identify the means by which the school will receive a racial and ethnic balance among its pupils that is reflective of the school district population. This requires at a minimum that the charter school adopt a student non-discrimination policy. It might also include other efforts such as marketing to seek out applications for underrepresented groups. The contract must list the requirements for admission to the charter school. This typically would include residency in the district or full or part-time open enrollment. For charter schools limited to certain grades, admission requirements would include attainment of those grade levels. If the charter school were limited to students of one gender, such admission restrictions would be noted here. This part of the contract should also describe the process for random selection of applicants if the charter school receives more applicants than it has room for. The contract may require the governance board to set enrollment limits by a date certain and/or create a waiting list for pupils not admitted. The contract should describe the manner in which annual audits are conducted. This might include who selects and pays for the auditing firm and authorizer access to charter school financial data and records and periodic reports. The contract must describe the procedures for disciplining pupils, which may reference authorizer district policies and procedures, or may require the charter school to create its own policies and procedures. Consider requiring the charter school to serve all eligible students, including students with disabilities. Also consider requiring that the charter school not expel or counsel students out, except as otherwise approved by the district. The contract must describe the public school opportunities for students residing in the district who do not wish to attend or who are not admitted to the charter school. This would typically be other schools offered by the authorizer school district. The contract shall include a description of the school facilities and of the types and limits of liability insurance that the school will carry. In some instances, the charter school will be located in a building owned or leased by the charter school, in which case the charter school might be responsible for the liability insurance. In other cases, the charter school may use space within the authorizer district, with the authorizer board assuming responsibility for the liability insurance. The final 1M contract requirement is a description of the fact of establishment of the charter school and the liability of the school district. This should be an expression of the autonomy of the charter school by making clear that the authorizer and charter school governance board are each independent of the other. There are many other contract provisions you might consider including in a charter school contract. Charter schools receiving federal charter school program funds must include certain mandatory provisions required by the Every Student Succeeds Act. Authorizers might also consider including NACSA principles and standards and/or other benchmarks strongly recommended by the Department of Public Instruction. You can find more information on these contract provisions in the new Department of Public Instruction contract benchmark documents available on the WRCCS website resource page. Charter revocations are governed by section 118.40(5). A revocation ends a charter school's operation before the end of the contract. This differs from non-renewal, which is a decision to not grant another charter school contract upon expiration of the current contract. The school board or other charter authorizer may revoke a charter contract for any of the following reasons. The charter school violated its contract with the school board. Pupils enrolled in the charter school failed to make sufficient progress toward attaining the educational goals under section 118.01. The charter school failed to comply with generally accepted accounting standards of fiscal management, or the charter school violates Section 11840. Revocation of the charter school contract is a serious decision that should involve school district legal counsel. This concludes Section 4, the charter school contract.